All right, welcome everybody to this tutorial. It's a very important tutorial. The tutorial actually segues with the training which we will do at the various levels. In other words, there will be certain content for the free training. There will be certain content for the introductory course. There will be content for the intermediate course, and there will be content for the advanced course. The training as is presented today really relates mainly to the advanced course because we're going to get into some important detail which is presented at the advanced course level, but will be of relevance to anybody no matter what your level is. So whether at the free, the introductory, or the intermediate, this will relate very much to where you are. Certain content will be made available tomorrow flowing from this tutorial at each of those different levels. So just watch the WhatsApp groups for that content, and there will be information coming through. I'm pleased to say that we've got over 100 registrations for this evening's tutorial, and it's gone very well. We started the first one, I think we were on about 22 2 weeks ago. Last week we had 55, and today we are up, as I say, over 100 registrations. I see we're on 31 attendees now, so people might still be filtering in a little bit late. This tutorial will be available on demand. In other words, a recording will be made available, will be distributed via the various groups tomorrow as well. All right, so I just want to start off by just orientating quickly onto the South African Medico-Legal Reports website. That's the hub where you will find access to all the content which is being produced by the South African Medico-Legal Reports. We communicate via the WhatsApp groups, but WhatsApp messages come and go, and when it gets busy in particular, you can't scroll back to find the information. The information that we put out, not the posts themselves, but the underlying material, is available on the South African Medico-Legal Reports website, and that is really your go-to point to get the access to the information nicely organized and presented appropriately. And so for this evening, turning to this evening's topic, you'll see that of the tabs, we've now added a tutorials tab. And the tutorials tab, and for those of you that do want to follow, I would advise that you follow if you can on a laptop or a desktop, because there's quite important content and information we're going to go through, which it'll be helpful to follow. I will broadcast it on the screen as well. If you want to just check on your own laptop or what have you, you can follow that. It's up to you, but I will broadcast on the screen and I will enlarge it so it's more easily viewable. And if you do want to go onto the site, just have a look at the tutorials tab, and you will then find this particular tutorial, the only tutorial on that tab at the moment, 20th of January 2026. And you'll see from the content on screen is that we're going to have a look at a matter of ZN versus MEC for Health, Province of KwaZulu-Natal, 20th of January 2026. That's today's date. That's the tutorial date, not the date of the judgment. I'll take you through the judgment details in a moment. But you'll see that summarized in the first portion of the tutorial page is a summary of the principles dealt with in that judgment. Now, there's a lot that's packed into this judgment. It's actually, from a teaching point of view, a very important judgment because it's firstly, it's not out of the norm curve. It's a standard sort of judgment that one gets when you're dealing with personal injury work. It comes up regularly, but it does demonstrate in very graphic terms what the courts expect of expert witnesses and what can go wrong when those expectations aren't met. And as I say, this is not an outlier judgment. This is a standard judgment that happens all the time in the courts. And so it's a good example. But it is also a judgment. I'm just going to call up the judgment itself. You'll see that on the tutorials tab, and you can enlarge it. But it is also a judgment which is written by Jackie Hendricks, who's a very senior judge in KZN. And for those of you that practice in KZN, Judge Hendricks does a lot of the personal injury work. Those that know her judgments know that she does long and thorough judgments, and this is no exception. This judgment runs into some 70 pages. For those who are interested in mediation, my understanding as of about a year ago, when Alan Nelson held an event down in the Western Cape, Judge Hendricks is the one that attended the mediation session. So she's, as I understand things, tasked with keeping an eye on mediation in KZN. So that's another aspect to Judge Hendricks, which is interesting. But you'll see that she's a very sort of a pleasant judge to deal with in person, but the judgments can be hard hitting, and you'll see this judgment is no example. It's the sort of things not to be trifled with. Just before we get into the judgment itself, you'll see in grey, certain personal and private details of parties or witnesses have been redacted from this document in compliance with the law and the SAMLR policy. Well, firstly, the name of the plaintiff has been redacted as he or she was a minor. But then we've also redacted the names of the experts that were involved in this matter because there are criticisms of those experts. And it's the policy at the South African Medico-Legal Reports not to publish those names unless absolutely necessary. We don't want to embarrass anybody. That's not the style that we adopt. We're trying to help experts when we don't want to embarrass them or hinder their practice in any way. So we have redacted the names. I can tell you that there's some very well-known experts that were involved in this particular matter. And I think really the takeaway point from that is that some very experienced experts in this case were criticized in the judgment. And so I think the first point is that the sort of fundamental principles that you're going to be exposed to a little bit now, and which we teach through our various training courses, are absolutely relevant to anybody, no matter what level of experience or expertise you have. I'm just going to take you to the end of the judgment, and I just want to take you to the order, and I'll go back to the heading in a moment. But you'll see that the order and what happened in this judgment, and I want to start with this because it gives a backdrop to the implications of what is discussed during the course of the judgment. But at paragraph 245, and as I said, Judge Hendricks writes long and very thorough judgments. She makes the following order, of two orders: in respect to the plaintiff's claims for past and future loss of earnings and future medical, hospital, and related expenses not specifically abandoned. So certain claims were abandoned, but of those that they persisted with, she granted absolution from the instance with costs. In other words, the plaintiff's claim in respect of those particular heads of damages, it wasn't dismissed. In other words, they can come back with supplemented evidence, but it really, for practical purposes, it's a hammer blow for the plaintiff, because what's happened is that they weren't successful, and she made an adverse costs order against the plaintiff. It's a heavy blow. And you'll see that it's squarely because the expert evidence was not properly presented in this matter. And that is the implication of not getting it right as an expert, and also to an extent the legal representatives, I think, must shoulder some of the blame in this matter, which is why you'll see I've redacted the names of counsel as well. But so that's the first point, just to be aware of the implications. It's really a bit of a disaster, this judgment. And as I say, it's not an outlier. This happens regularly, and the reasons for it happening are actually understandable when you go through the judgment. Now, just before we actually start unpacking the judgment, I do just want to take you back to the tutorial page. And I just want to take you through how this first document works and what is being referred to there. So there's the formal heading, there's the report heading, and then reflect the formal court heading. So what this is we've got the first column, and I'm actually going to I'm not sure what's happened to the header here. That should have come up, but this is the topic being dealt with in the first column. The second column is the reference to the expert witness guide. And if you go to the textbooks, you'll see the expert witness guide deals with all of these topics. Everything that's dealt with by Judge Hendricks in this judgment is dealt with in the expert witness guide and forms part of the training related to the expert witness guide. And these are the legal principles which are set out, and which just in very succinct form, the principles dealt with in these are the paragraphs of the judgment, the expert witness guide, and then the principles themselves. And we will work through this in some detail during the course of the evening. Insofar as the judgment itself is concerned, you can have a look at that on the full screen. And And I'm just going to take a moment here just to open another tab, and then I can just follow both of those simultaneously. But just while I do that, I do just want to mention to you that there's some very common themes that come up in this judgment. Themes relating to some very fundamental principles, such as how do you qualify as an expert? How should addendum reports and supplementary reports be dealt with? How should the facts be managed? When do reports go stale? What's the order of the witnesses in which they must be called? How must joint minutes be dealt with? And if we just spend a minute or two, and I won't be able to go through the entire judgment, it's 70 pages, but I do want to touch on these key points and the principles reflected in them. So you'll see, firstly, what the first point that I want to have a look is the formal heading. And for those of you that have the expert witness guide, you'll see at paragraph 3.6.1 of the expert witness guide, when we deal with the expert report and the proper way to write an expert report, the formal heading must be included in the expert report. Now, that is a fairly obvious proposition, but it is important to appreciate. And for those who are new to the field, it's worth having a look at the formal heading. And here we have it. Here's a judgment with the formal heading. It gives you the High Court of South Africa, so we know which court we're in. It gives us the KwaZulu-Natal Local Division Durban, so you know which division you're in, which province you're in. You get the case number, and then you get the matter between the two parties. And as I say, the names of the one party have been redacted, the plaintiff, for reasons I've dealt with, and then the defendant as well. There's then a summary of the order. The format of the judgments is sometimes slightly different, but very often you get a summary of the judgment on that first page. And then you also get the order, when I say the summary of the judgments, it's really the order, more accurately, I beg your pardon, not a summary of the judgments, it's the order made by the judge. And then we have the judgment itself, which you will then see that the judge then sets out in a particular way. Now, what's important to emphasize at this point is if you have a look at the first points, the formal heading. So you must reflect the formal court heading. And when you look at the judgment and you see this formal court heading, just to make the point that formal court heading should be on all pleadings so the formal court papers, and that should be accessible to those who don't know where to get that formal court heading from. That's not only on the judgment, it's on what we call the pleadings as well, and the notices. So the bundle of formal court papers, you'll find it from there. Then we have, insofar as the pleadings are concerned, I just want to take you through how Judge Hendricks approaches her judgment. So she starts off with introduction. And just to demonstrate, you'll see from the approach which we take, and we emphasize this when we deal with the expert report, it's very important to set up the content of what it is that you're going to be dealing with in your report. Because, you don't want to just start in the middle of nowhere. You do need to set up what it is that you're going to be dealing with in this report. And you must remember, and I emphasize this point, you're dealing with busy judges and busy practitioners, busy experts, busy lawyers. It's very good to have a clear mastery of the formal heading and then the case details. What is the case about? And you can see the paragraph numbers referenced on the left-hand column there, and then the expert witness guide commentary on it. But you should set out the case details, and you should include an executive summary setting out the key points to be traversed. Now, what I mean by that, and you'll see from the judgment, how does the judge lead into the judgment, and the lessons to be learned here for writing an expert report. You'll see she starts off, this is the judgment in respect of the reconvened quantum trial, so liability had been dealt with, you can already see that, of this matter in which the issues for determination have been identified as follows. It's a very important point that experts very often don't appreciate, and you will see that it comes back to haunt the experts in this case, those that have trained with me know that I emphasize an identification of the issues. It is very important to be very clear of the issues that you are addressing, whether it's in the written evidence or whether it's in your oral evidence. It doesn't matter. Those issues, and they do change over time. It happened in this judgment. The issues can change, and it's very important that whatever stage you're at, whether you're writing your expert report or about to give evidence, whatever stage you're at or doing a joint minute, you must understand what the issues are at that time because it's a moving target. So the first point you'll see what the judge does is she identifies the issues very crisply. Now she knows what she has to apply her mind to in this judgment. It's set out in the very first sentence. She's already getting her thinking clear. So in which the issues for determination have been identified as follows, and there are 3 issues. And we should all be familiar with that: the past and future loss of earnings, past and future medical and related expenses, and the rate of inflation applicable to the calculation of same. So there's the 3 issues. Look at that last one, the rate of inflation, something that's quite easy to overlook. But by sitting down and going through the mental discipline of identifying the issues correctly, and we'd go through the training how to identify those issues correctly. But the first thing is you must identify the issues correctly so that you know what it is that you have to address. Okay, that's the first point. Then the second point is this, and you will see from paragraphs 1 to 4, and then again in paragraph 78. I'm not going to go to 78, but I'll just take you through paragraphs 1 to 4, and let's just have a look at them, and then let's pause and reflect on where we are in our understanding of this case. So paragraph 2, the plaintiff instituted action against the defendant, and remember the defendant here is the provincial MEC for Health, so Department of Health, for damages arising from the negligence of its doctors and nurses who treated her at King Edward VIII Hospital on the 7th of February 2009 when a caesarean section was performed. It is common cause that a post-surgical swab was left inside her body, which resulted in septicemia and various post-operative complications. So you see, immediately we're setting the stage here. So we've got the issues. Now we're setting a factual background. She's setting a factual background. So the reader immediately starts getting a mental idea of what's in issue and what this case is all about. And just to emphasize, we're busy. The courts turn over a huge volume of cases. We turn over a huge volume of work in our practices. It's very important to get straight in so people understand. So even though it's a lengthy judgment, she doesn't wait till paragraph 20 or page 20. She's immediately into to frame what the judgment is going to deal with. Then 3, very important, the defendant conceded negligence. So immediately we know the question of liability is not an issue in this judgment. There from paragraph 3, we're already orientating ourselves very accurately. And acknowledge liability for the plaintiff's damages. There we go. So there's an acknowledgement of liability. The matter was thereafter enrolled for the determination of the plaintiff's quantum of damages. So we know exactly what she's dealing with. We know exactly what the issues are. We know where the case is. We know what's been already decided, and we're moving from there. Then there's just a bit of a procedural matter about enrollment for trial in October 2018. That gives a history that's relevant for other purposes. For our purposes, less applicable. And the parties, the matters adjourned, and then there was an order agreed on awarding the plaintiff an amount of 1 million rand in respect of general damages. So now generals have been dealt with. They're also out of the picture. And then the parties were adjourned for the parties to attempt to narrow the remaining issues. And if you look at the judgment in full, you'll see that becomes relevant to the costs order, that the judge criticizes the plaintiff for not properly narrowing the issues, despite a specific adjournment for that reason. And also in the pretrial proceedings in KZN, we have a particular practice directive, particular way of narrowing the issues. And there were at times judges recommended to the plaintiff that they apply their minds to narrowing the issues, which the plaintiff didn't do, and was an important factor in that cost order that we've already looked at. Okay. And then to attempt to agree on the applicable rate of medical inflation, as well as for purposes of the experts' availability. So if we then have a look at the formal heading, the case details, set out the case details, that's on the formal level, and then immediately. And you'll see that when we train on writing an expert report, we talk about the executive summary, right? And how important the executive summary is. Those that have done the intermediate course in particular will know that. And an executive summary setting out the key points to be traversed. Now, that's not quite what Judge Hendricks has done in this case, but you can see already there is something of an orientation and a setting of the scene right in those first few paragraphs. And then we've got paragraphs 1 to 4, the background to the dispute, which we've just looked at. So include relevant foundational information, immediately set the scene. Then we get let's go to paragraphs all the way 1 to 12. She deals with the issues in dispute. And the comment is it's extremely important to clearly identify the issues in dispute. And that is important for numerous reasons. And if you haven't, in fact, clearly identified the issues at that point in time in detail, you are running the risk of falling seriously foul of the correct approach um, to uh, to dealing with expert evidence, and you can have the sorts of consequences that eventuated in this case. All right, and then so if you just go through to paragraph 12, you'll see then in paragraph 5 she starts dealing with the particulars of claim, which is the pleadings. So she's now analyzing the pleadings. The pleadings are important because they give you the formal statement of case by the two parties. The pleadings can get a little complex if there are all sorts of pleadings that can come into play, but the legal representatives should guide you through the pleadings and should identify the issues and the questions which need to be decided, with your starting point being the pleadings, because that's where the formal identification of those issues starts. And from there, you then develop in any particular case what it is that the particular issues are. And I'm not going to go through all of this word for word. The point is just to demonstrate the concept, which is you'll see that she then goes through the pleadings and elaborates on exactly what is in issue in the case. So, for instance, if we just take paragraph 6, in respect of future hospital and medical treatment, the plaintiff indicated she would require further treatment for a fistula. So, a fistula developed, prolonged psychological and supportive therapy, treatment for the extensive scarring on her abdomen, further treatment and management of the colostomy, and further surgery for the closure of the colostomy. So, what she's doing here, she's developing that where she initially located these three issues: the past and future loss of earnings, the medical and related expenses, and then the inflation rate, less relevant to this particular aspect. But you see, she's now developing that, but she's still setting the scene. So important to bear that in mind and to reflect on whether there's, and also important for people doing expert reports to take note of here. You'll see that already there's a very clear logical progression. So the judgment is logically reasoned right from the formal heading into the quick identification of what's in dispute and elaboration of that, and then developing that. Now she's set the quick scene, and now she's getting to a bit more detail, putting a bit of meat on the bone and she's already identified what the important issues are. Now that's important because the chances of her now waffling and straying from the point are very much reduced. So she can now go into this next phase of putting some details in place because she knows exactly what it is that she has to address. And she will have worked out already what her end result is. And so she's following that train of logical reasoning, which we emphasize and which is so key to expert reports. And those who will know that the trained will know Michael's case, very important. How the courts approach, particularly where the disputes between experts, but any assessment of evidence will that their principle of logical reasoning is absolutely critical. All right, then she identifies, and here she gets onto the formal identification of the issues in dispute. All right, so that we're saying paragraphs 1 to 12, and you can see these, 1, 2, 3, 4 paragraphs. She actually specifically sets out the issues in dispute, which is a very good exercise to do because it means that there's a mental discipline of specifically writing down or typing out, however you want to put it, the issues that are in dispute. Very, very important to get that right. And just the discipline of going through that is tremendously helpful in getting that process of logical reasoning going. So you'll see she spends 4 paragraphs on that, and something also just on the style and the way that this judgment is written. As I said, it runs into 70 pages eventually, but it's economically written. There are no big fancy flowery words. The style is to the point, it's succinct. And the reason is because she can do that is because she's already channeling her thinking. And I'm not going to go through all of the details there. We don't have time for that. We will unpack this in the advanced training course. For those doing the advanced training course, we will be looking at this judgment in quite some detail. But we have to move quite quickly through the judgment this evening, and we'll see how far we get. But as you can see, there's some very valuable principles that emerge. All right, so that's the issues in dispute. Then she then goes through, and I just want to show you not so much the medical expenses, but I just want to show you how she goes through and assesses, and she assesses in great detail every expert, and she sets it out in detail. Now, there's a technique to this, and it goes back to a point I made earlier. When you know what it is where you're heading, and you know the logical progression of your argument, which is even a judgment is effectively an argument. An expert report is an argument. When you know the train of that argument, you know what the issues are, and you know what your conclusion is, and you know the logical reasoning that's going to get you to that conclusion. It is then also very much easier for you to decide, all right, there's certain aspects where I really have to pay attention to the details. And I need to set out those details because details are very important. Now, there's a big difference between wasteful detail and what I call waffle, which you get in so many reports when people don't know what they're actually supposed to be doing, and they just pad that report with a whole lot of, you can see it's just sort of copy and paste, as opposed to a reasoning process. This judgment is a very good example of a reasoning process where, in the appropriate stages, there's attention to detail. And just have a look at the type of attention to detail that the judge gives. She goes through almost to the point that it's tedious. She goes through expert by expert, but every expert that she deals with, she's laying another brick in the wall, and she is building an argument, and it makes it very difficult to attack that argument later, because she's building it step by step, brick by brick, and that is something that experts should take note of. The way that you develop an argument, the way that you build a strong case, which is what the judge is doing. And you'll see she goes through all of what she's doing at this stage. In those who, and I would recommend going and having a look at this judgment, but you'll see that she goes through carefully all of the plaintiff's expert witnesses, and there's a specific reason for that. There's then some reference to background factors, but she is going through all of the. You'll see here, Dr. AMG, a urologist, completed a report. His report first, so she summarizes the report. Then she goes through all the important aspects of that report. This takes skill, and it takes hard work, and it takes dedication. But you'll see that she goes through expert by expert. She goes through. And then I just want to show you, all of this is plaintiff's experts. Then she gets to defendants. So look at how much she's got to paragraph 57, and she's dealt with plaintiff's experts. Then she gets to paragraph, look at the defendant's experts, paragraphs 58 and 59, very, very briefly, almost cursorily dealt with. Why? Because she knows where she's going with her reasoning. She knows what her argument is, and she knows she does not have to spend pages and pages on the defendant's experts. In other words, what she's doing here is not a tick box exercise. She's applying her mind, and she's reasoning. She's got a reasoned argument that she's making out. And as we've already seen, not to give the game away, we've already seen that the upshot of it was that she found that the plaintiff had not led sufficient evidence to make out a case for judgment in their favor as prayed. And so remember, she gave absolution from the instance. What that is when there's not enough evidence, but that evidence could be supplemented. So she considered it, but she didn't dismiss the action. She granted absolution from the instance, so the plaintiff can come back with supplemented evidence. Okay? So, but because she had that in mind, she went through extensively the plaintiff's evidence. But she didn't have to go through extensively the defendant's experts, because you'll see that she accepts what the defendant's experts say. The thrust of this judgment is to criticize the plaintiff's preparation and presentation of evidence. So you see, for that reason, she doesn't then go and waste a lot of time on unnecessary waffle. So just to really drive this point home, what you should be appreciating is that the judge has judiciously focused on an aspect of the material which needs close scrutiny, being the plaintiff's experts, and broken it down in detail as we look page after page. When it comes to defendant's experts, she has exercised her judgment. It's not necessary to go through that in order to make the argument. That, to me, is a very important point. So she knows what she's doing, and she's building a case. All right, and then that takes us through to paragraph 60. Then I just want to, now she starts with joint minutes. The joint minutes come into this particular judgment. You'll see the general principle governing joint minutes in the expert witness guide is paragraph 4.2.3. The binding nature of joint minutes was reiterated. So what she goes through here is that she says she'll return later to the joint minutes, but she makes the point that the joint minutes were concluded, and she deals with it in detail a little later on in the judgment. And in fact, we can maybe go to paragraph 125. I'm going to just skip out of time here. Sorry to make your eyes swim, but let me just quickly go to paragraph 125. Yeah, you'll see that there were various additional documents were made available, addendums and supplementary reports and the like, and we will have a look at that in some detail a bit later. I think let me rather just stick to the process here. And then, so at paragraph 67, she then deals with this aspect. If you look at the sentence, it became evident during the course of Miss C's evidence that the basis for objecting to the third report, so there was an objection to one of the witnesses' reports, and the basis was that what was reported to her by the plaintiff constituted a deviation from the joint minute, which existed between Miss C and Dr. C. Okay, so a joint minute had been concluded. There was now an attempt to deviate from that joint minute, and there was an objection to that. And why? Because if you look at that, the general principles governing joint minutes, the parties may not ordinarily deviate from the joint minutes, and the court is probably bound and certainly entitled to accept the matters agreed between the parties in the joint minute. Now, let's just pause on that particular point because it's very important for experts when they're preparing for trial. A joint minute is a very, very important document, and you can see from this particular comment, this particular item, that the status of joint minutes is that once you've agreed joint minutes, those joint minutes are probably bounding on the court. It hasn't really been decided, but certainly the court is entitled to say, I'm not prepared to allow you to deviate from what's been agreed in those joint minutes. In other words, when joint minutes are concluded, it is not an exercise that should be lightly done or should be done without very close scrutiny to what exactly it is that is being agreed to in that joint minute. And I would add another point to that. It takes work to understand what the issues are, what the background is, and before a concession is made in the joint minutes, one needs to understand the case very carefully. And you'll see that there was in fact an objection now to a report, a further report being handed in because it didn't coincide with the joint minute. So this is where there needs to be thought given to what the issues are, what's being addressed by the expert witnesses, and how that affects for instance, the joint minutes. Okay, and then the next one is at paragraph 125. We can have a look at that in a moment. But that deals with expert reports being outdated. And then I just want to turn, before we go to that paragraph, I just want to turn to paragraph 72 and 73, just to start giving you a background on this. So paragraph 72 and 73. During cross-examination, she confirmed she was instructed to assess. So this is now an expert giving evidence about assessing psychological sequelae associated with a medical incident under review, and was not asked to consider the effect of the sequelae on the plaintiff's employment prospects or employment capacity. This goes to the instructions received by the expert. It's very important that those instructions are scrutinized by the expert, and that the expert applies his or her mind to those instructions to see that those instructions fit in again with the issues and with the development of the case and with the reasoning process that's being taken not only by the particular expert, but also the overall case by that party. So bearing in mind what other experts are thinking. So it takes high-level thinking to draw all these strands together in a coherent way. But it has to be done with a methodology that allows you to get to that outcome, because these issues are complex, and that is how a properly drafted and structured expert report assists you to get to that particular methodology. And we deal with that in the intermediate course as to how to properly draft an expert report to allow you to take all these principles into account. She acknowledged that counsel for the plaintiff prefaced her evidence on the basis that she would testify relating to the capacity of the plaintiff as a clinical psychologist. Ms. C confirmed that her report does not specifically deal with that aspect, and conceded that it is unusual for her to deal with employment and earning capacity in her report as a clinical psychologist. Now you've got a clinical psychologist straying into the territory of the industrial psychologist. You'll see she says it's unusual for her to deal with employment and earning capacity in her report as a clinical psychologist. Well, the reason it's unusual is because she shouldn't be doing that. The industrial psychologist should be doing that. She's a clinical psychologist, and you'll see that they run into hot water on that point. There are a couple of other points they run into hot water on, but that becomes a very critical point in the decision which the judge eventually reaches in this case. So that's paragraph 72 and 73, and then I just want to go to paragraph 125. As I say, I'm not going in depth into every paragraph and dealing with every last principle here because we have limited time, but it's just to give you something of value and to see why this judgment is important and the types of issues that come up and should be properly dealt with by experts. All right, so you'll see the paragraph 125 if we go there. You'll see she's actually dealing with the defendant's evidence at this stage. The defendant, I'm going to just backtrack to paragraph 124 to contextualize it. The defendant elected to lead only the evidence of its industrial psychologist, Dr. K, at the trial. He had prepared an initial report after assessing the plaintiff and a joint minute with Miss H in September 2019. Dr. K confirmed he had been requested by Miss H to complete a further supplementary joint minute with her after she completed a supplementary medico-legal report dated the 11th of April 2023. He declines to do so. So he refuses now to participate in a further supplementary joint minute. And his reasons are instructive. At the time of the request, certain additional documents were made available to him. So at the time that now there's a request for a further joint minute, and there are additional documents that come down the pipeline, being the letter of Professor G, dated December 2016, an addendum by Dr. G, the urologist, August 2018, and the supplementary report of Ms. Prinsloo, dated 22nd of May 2023. Dr. K indicated that his reason for refusing was as new information came to light as a result of such reports. Given the contents, he formed the view that his report of 23rd August 2019 was outdated and that his opinion was likely to change. So what I want to stress here is you see how this particular expert had his eye on the ball. He was aware of the issues. He was aware of the changes that came about as a result of these additional documents coming to light. Okay? And he then formed the view that his original opinion is outdated, and then consequently the joint minute, which he had previously prepared with Ms. H, dated 17th September 2019, was also outdated and required reconsideration. In other words, he was saying, I'm not prepared to participate in a joint minute because I've done a report. There's now additional information come to light, which makes my first report outdated. I need to reconsider. And I need to think about, is that still my position? Do I change my mind? Do I need to supplement my report? What do I need to do? The court then goes on to assess that situation and says 4 years had passed since his initial assessment. Now, those of you that know will be aware that 2 years is a rule of thumb for reports going stale, and the court, it doesn't apply with every single report, but as a general rule, once you get past the 2 years, it's a sort of sell-by date of the report, and you've got to consider the other expression that is used is superannuated. So the report becomes superannuated or stale. And he was not in a position to provide any supplementary report or participate in compiling a joint minute unless, now look at what he says, he needs to perform a reassessment on the plaintiff. The plaintiff must be medically reassessed by the relevant medical experts as 14 years had passed since the initial treatment by them and 5 to 7 years had passed since their report. So now because of this effluxion of time, this is a medical malpractice, negligence matter, a lot of time has gone by. You do find that particularly in these medical negligence cases, but even RAF cases. And you've got to keep an eye on the clock. The superannuation of reports, those practice will know. It's a very real issue. It can be a bugbear, but look at how the court deals with the superannuation, with the stale report. Additionally, he was not au fait with the exact physical status of the plaintiff currently. These are all valid points. He was aware that the stoma was closed and that in relation to those medical issues, issues were resolved. I'm not going to go into medical issues. I think we can pick up basically what the issue here was. There was a fistula which occurred as a result of the cesarean section, but we were not going to get into the medical technical details. However, the reports of Miss H seems to indicate that the plaintiff was complaining about pain and difficulties, more specifically psychological fallout, which in his opinion were not related to the incident. Then, having regard to Miss H's report, the plaintiff is coping very well at work, and according to the HR department at Macro, there have been no complaints about the plaintiff's work performance. He testified that there was a huge incongruence between her work performance compared to the reported psychological conditions and a clinical psychological assessment, and one by a psychiatrist, would shed further light on the plaintiff's current condition. He testified that as an industrial psychologist, he's not able to perform such an assessment. So again, he gets this right. He knows what the boundaries of his expertise are, and he sticks to it. Nor would he venture to do so, as his area of expertise as an industrial psychologist is in the domain of optimizing human behavior, where other categories of psychology are inclined to focus on remedial and therapeutic therapies to change abnormal behavior to normal behavior. Dr. K was adamant that given the nature of the complaints which the plaintiff has reported, especially to Ms. H, a report from a clinical psychologist and a psychiatrist were essential and would shed further light on the plaintiff's current condition. I just want to just take a moment here to reflect on a very important point when it comes to the approach of expert witnesses and what makes a good expert. You see, this particular expert understood the principles and understood what he was being asked to do and what he should do and what he should not do. And he was firm and strong on that. And he articulated his position rationally, and he stuck to that position. So his foundations were firm, his approach was therefore correct, and then he stood his ground. Okay? So take cognizance of that, because that is what, as advocates, we look for in an expert. Somebody who's right and is prepared to stand his or her ground. We don't want somebody who's wrong and is prepared to stand his or her ground. In fact, in this very case, there's a criticism of the other industrial psychologist who refused to make concessions. That came up in this judgment. So you mustn't be wrong, you must be right, but then you need to be strong and stand your ground. And then I'm just going to go, there's more that the judge goes through in assessing, but we're running a little low on time. I just want to then take you to the analysis. The court then says, so I want to just remind myself, just orientate myself here for a moment on any other important aspects. Yes, I will deal with stale reports in let's just have a look where we are in the judgment, 126. Yes, let me just have a quick look. That's where this question of stale reports came up, and we looked at that, these years that had passed. I just want to deal with stale or superannuated reports. I have touched on it, but let me just complete what I want to say on that. So you see that at paragraphs 126, 127, 131, and 132, the timing of the expert report becomes important. Timing of the report matters for all sorts of reasons. The one we're looking at now is this question of reports going stale. And I made the point earlier that not every report goes stale, but once you pass the 2-year mark, be aware of this approach by the courts, and be aware that you may need to supplement, or you may need to do an addendum to your report, something along those lines, where you must deal with this question of 2 years having gone past. And if the 2 years are not relevant, because the plaintiff, for instance, has reached MMI and there's going to be no change after that, or whatever it happens to be, it is advisable to put something before the court explaining that position, so that the court has material to go with and is aware that the report, in fact, is not stale. So that's very important to appreciate. Okay. And then I just want to turn to paragraphs. Let me just go through this a little bit now, and just to wrap this particular point up. All right. So let's have a look at this. If we at the analysis, page 134. I'm just going to take you to paragraph 136. It just gives you a flavor of what Judge Hendricks concluded. So what we are busy with now, she set out what actually happened. So the facts, she started off orientating herself, right? These are the issues. She's then unpacked them in some detail. She's then gone and analyzed in a lot of detail the plaintiff's experts and what they all said. and has then gone through the defendant's experts. In particular, there are a couple of points that the defendant's industrial psychologist raised, which she's also dealt with in detail because it's going to lead her to her conclusion at the end, where she's going to say that the plaintiff's job was not properly done in this case. I'm not prepared to grant judgment. Now we get to the analysis section. Now, the analysis section is often very important because here's where you find the legal principles. So she goes through analysis is quite lengthy, so I'm not going go through the whole thing, but I'm going to just pick up a little bit of a flavor of where she was going. So at paragraph 136, several problems arise with the plaintiff's attempts to discharge the onus of proving her damages. Now remember, the plaintiff bears the onus. She has to prove her damages, okay? She says, I will firstly deal with the viva voce evidence of the witnesses, in other words, the oral evidence of the witnesses. And then she goes through, Ms. C conceded during the course of cross-examination that her diagnosis using the DCM-5 was to deal with the psychological sequelae of the incident. Even though she commented on and her evidence appeared to be focused on the plaintiff's potential earning capacity and her employment, that was not her area of expertise, nor her role in terms of her mandate. So we deal with instructions. Sometimes instructions are not appreciated as to how important they are. It's important to actively assess your instructions and to communicate with your attorneys as to how those instructions should be approached and whether the instructions are accurate. And one of the things to look for in instructions is if you're being asked to do something which is not in your field of expertise. Now, it seems in this case that the instructions were not for her to go outside her field, but she did. She ended up, you see the sentence there, that she commented on aspects that were outside, not, as the judge puts it, was not her area of expertise. Okay, so now we're running foul of that fundamental principle. In the course of her evidence, she was also asked to comment on the aspects of the plaintiff's early retirement and the plaintiff's ability to continue in her employment. This is not within the purview of a clinical psychologist. There were several objections to the admissibility of this portion of her evidence, rightly so, in my view, given her area of expertise. In other words, those criticisms were well-founded, and it is one of the main planks on which this judgment rested in finding that the plaintiff had not discharged her onus in proving her damages. And then there's more comments along those lines. I just wanted to point that particular line of they see the judge adopting a line of reasoning, and she's now building it. She's looked at all the expert evidence by the plaintiff. She's now homing in on what the specific criticisms of the plaintiff's case, as it was articulated, in fact are. And then we go to paragraphs 152 to 153. I just want to take you to that, as to what the expert's fundamental to the duty to the court is. And you'll see that the judge deals with some well-known judgments. Those who've done the intermediate course will be familiar with B versus Road Accident Fund, very well-known personal injury judgment, which we look at in detail. And then 152. So now we go, you remember that when we did the general principles governing expert evidence, one of the key principles that we looked at was what's the proper role of the expert witness under the purview of what is the proper relationship between the expert witness and the courts? And within that umbrella of the relationship between the expert witness and the courts, and there's quite a bit that goes into that, but a very important component is what is the proper role of the expert witness? And there are a number of judgments that deal with that. Judge Hendricks, in her judgment, referred to the Supreme Court of Appeal decision. And for those that don't know, Supreme Court of Appeal is the second highest court in the country. Only the Constitutional Court sits above that. So when the judge refers to the Supreme Court of Appeal, it has a particular resonance. This judgment has particular gravitas and particular importance. It is well established that an expert is required to assist the court, not the party for whom he or she testifies. Objectivity is the central prerequisite for his or her opinions. In assessing an expert's credibility, an appellate court can test his or her underlying reasoning. Remember, we've looked at that, and is in no worse a position than a trial court in that respect. Let's not worry too much about the difference between the trial court and the appellate court. That's to do with how an appeal court can approach the matter. But the important point to take note of is that this process of reasoning is what is critical. So that reasoning process has to come through in the report, and it has to come through in everything that the witness does, because that's how the judges assess it. And the point is, insofar as the objectivity of the expert is concerned, you often get an approach by experts where they know about this thing of objectivity and that you need to be impartial and unbiased, but really they're going to tell the plaintiff's attorney or the defendant's attorney, instructing party's attorney, what they want to hear. That, in the long run, can be a very bad idea, as this case demonstrates, because if you are not able to justify your position when you're under cross-examination in the heat of the courtroom, ultimately, you can end up in hot water. And the judges very quickly become aware of experts who are totally biased and that refuse to make any points against the party instructing them. What the judge is looking for is a reliable expert, whether it's the written portion of the evidence or oral evidence or both. The judges want a reliable expert because an expert at the end of the day is there to assist the court. That's the definition of expert evidence. An expert can only give an opinion because he or she is in a better position than the court to express that opinion. That's the basis for expert evidence. And here's a nice quote to that extent. An expert must be made to understand. And you look at DeMont J.A., another appeal judge, Stock versus Stock. You see how firmly the judge is putting this, that he is there to assist the court. If he is to be helpful, he must be neutral. The evidence of such a witness is of little value where he or she is partisan and consistently asserts the cause of the party who calls him. I may add that when it comes to assessing the credibility of such a witness, this court can test his reasoning and is accordingly to that extent in as good a position as the trial court was. That's the last comment is to do with the appeal court again. But the rest of that comment absolutely applies. Okay. And I just want to take you to what Davis J said in Schneider and others versus AA. In short, an expert comes to court to give the court the benefit of his or her expertise. Agreed, an expert is called by a particular party, presumably because the conclusion of the expert using his or her expertise is in favor of the line of argument of the particular party. But that does not absolve the expert from providing the court with as objective and unbiased an opinion based on his or her expertise as possible. An expert is not a hired gun who dispenses his or her expertise for the purposes of a particular case. An expert does not assume the role of an advocate, nor gives evidence which goes beyond the logic which is dictated by the scientific knowledge which that expert claims to possess. So that then gives you a very good orientation as to what the role of the expert is. That then influences the relationship between the expert and the court, which is central to what expert witnesses do, whether the matter goes to trial or not. Establishing that expertise and giving good, strong reports, as happened in this case for the defendant's experts, where he was right in what he said, he took a position and then defended that position, and at the end of the day was justified. And in fact, there was a tremendously beneficial effect for his client because he knew what he was doing and he located himself firmly within that. All right, there are a few additional points. I think I've covered the main points. That we're nearing the end of the time allowed, but just to then summarize, this is an important judgment because, as I say, it's not out of the norm curve. It's a standard judgment, but it demonstrates why things and how things go wrong, and these fundamental principles then get applied in practice and need to be understood and properly adhered to. Otherwise, this is what happens. I do just want to announce that if you go and have a look at the expert witness training which we provide, we are running an introduction to expert witness course starting in February of this year. And here we have the introduction. You can go and have a look at it for yourself. The cost is 999 Rand. You will deal with all of these fundamental principles. We will locate you very squarely within the domain of an expert so that you understand the overall landscape. And all of these principles, you will then have at least a passing knowledge of all of these principles so that you know what's expected of you. The course will run over 3 Thursdays. That's Thursday the 5th of February for 2 hours in the evening, Thursday the 12th of February, and then Thursday the 19th of February. That's the course for 1,000 Rand. And then we do have a special on. I know Che posted today that there's a special where you will get this course free if you sign up for the intermediate training course, which starts on the 26th of February. So the Thursday following the introductory course, we start the intermediate course on the 26th of February, and you'll see it's 5 sessions. It'll take you through to the 26th of March. Now, the intermediate course, I know that there are quite a number of names here of people who've done this intermediate course. The intermediate course will deal with these principles that we've touched on in a structured, detailed way. So the introductory course will locate you and explain to you what the lie of the land is. The intermediate course takes you into detail so that you understand the principles. And then the advanced course, which is going to start now this coming weekend, the advanced course picks up from the intermediate course and takes those principles, that detailed knowledge, and transforms it into actual skills that to be internalized and developed by the expert witnesses and by people instructing experts or dealing with experts over the years to come. So that's the basic structure of the program. I think we're at an end of our time. We will have another tutorial next week. Please spread the word about these tutorials. They really are necessary, as you can see from this particular judgment. Go to the website. Shay's got links to the website, and please sign up for these courses. It's an investment in your professional expertise that I would very much encourage you to do. I think you'll get a lot of reward for the money that you put into it. So from me, it just remains to say thank you very much for your time. I look forward to next week. I really enjoy this training, and I enjoy this whole area of the law. It's fascinating dealing with experts. So thank you for your time. The recording will be available. I'm not sure how many people made it eventually onto this 58. All right, so we've probably got others that are going to watch the recording now over the next few days. And please invite your colleagues, and we will engage with you on the WhatsApp groups between now and next Tuesday. Other than that, I know the year's starting in earnest, and the courts are starting to crank up, and we're starting to crank up our activity as well. I hope you have a prosperous year and a successful year, and wishing you all the best. Thank you for your time and for giving me this hour of your time.